You locked your phone, you protected your accounts, and you used strong passwords. But if something happens to you tomorrow, there's a very real chance your family won't be able to access any of it. Not your money, not your crypto, not your photos, not even your email. This is one of the biggest estate planning blind spots we see, and it's becoming more common every year. Most people think estate planning is about houses and bank accounts. In reality, a growing portion of your estate exists behind passwords. That includes online banking and investment accounts, cryptocurrency and digital wallets, email and cloud storage, social media accounts, online businesses, websites, and monetized content. Here's the uncomfortable truth. Having a will does not automatically give your family access to any of this. Families assume they'll be able to call the company, show a death certificate, and get access. That almost never happens. Most platforms are legally prohibited from granting access unless your estate plan specifically authorizes it. Even your executor can hit a brick wall. What I see instead is accounts frozen indefinitely, crypto lost permanently, business revenue cut off overnight, and personal photos and documents gone for good. Good intentions don't override privacy laws. Ohio law allows executors, trustees, and agents to access digital assets only if your documents clearly say so. If your estate plan is silent, companies default to no access. Your plan should spell out who can access digital accounts, which assets they can manage, whether content like emails, files, and messages can be viewed, and how online financial assets should be handled. Without that language, your family's hands are tied. Cryptocurrency isn't like a bank account. If no one has the keys and legal authority, it's gone. Not delayed, not tied up, gone forever. This is exactly why crypto holders need more than a basic will. Without planning, I've seen families lose access to significant assets with no legal way to recover them. For people with crypto, online businesses, or complex digital assets, a trust often makes far more sense than a will alone. A properly structured trust can avoid probate delays, grant immediate authority, keep sensitive information private, and protect business continuity. Trusts aren't just for the wealthy anymore, they're for people whose lives exist online. This is another mistake I see too often. Wills become public records. Writing passwords in them is like taping your house key to the front door. A better approach is to assign secure password managers, encrypt digital inventories, grant legal authority through estate documents, and keep access instructions stored separately. Estate planning is about permission first and access second. When someone passes away, and the family knows there are digital assets, if no one can access them, then no one knows what's missing. By the time they call an attorney, the damage is already done. This is exactly what proactive estate planning prevents. So if you have online financial accounts, cryptocurrency, digital property or content, or an online business, your estate plan needs to reflect modern reality, not outdated assumptions. Call estate planning attorney Chuck Bendig today. Will ensure your digital assets are properly protected.